Hi, it's Professor Moylan, and I'm so excited to be joined by two partners from the Northeast Law Center, Alyson, Aleman, and Frank Herzog, who are both experts in estate planning. The Northeast Law Center specializes in estate planning, trusts, trust administration, wills, and probate. Well, I'm going to let them talk about their specialty. But first off, both Mr. Herzog and Ms. Aleman, thank you so much for agreeing to guest lecture our students virtually.
You're very welcome.
Thank you so much
Thanks
for having us.
Absolutely.
And let me just start with the really basic question. What's involved in estate planning?
So Frank, you want to take that one or you want me to?
Yeah, where do we go? Well, I think as a starting point, there really, where do we go? There's two general principles. I mean, you're planning for incapacity and you're planning for death. Those are really the two things. I think in the old days, and I'm going to put myself in that category, attorneys would just basically draft a will and, get paid and we're done. I think things have changed. None of us, at least I can't speak for myself, Professor or Alyson, we're not prophets. I'm not a fortune teller. I don't read tea leaves or coffee grinds, although I do bring as a prop my magic 8-ball. So if any of your students or anybody else would like to use that, be more than willing to. As I go through this, and I'm sure Alyson as well, I use real life things and real life cases because it's just it's easier to remember, and they're real life situations, and I think we can all apply them. So really using kind of a holistic approach now, trying to see about the entire family, not only just my clients, maybe a husband and wife, mother and father, but also downstream, children, grandchildren, grandparents, whatever the case may be. So really there are two scenarios when we're doing or looking at an estate plan. It's planning for incapacity, really while we're still living, things such as something happens to us in a car accident, or we have an elder parent that may be going into a nursing home or a long-term care situation, or ourselves. So those are the things, these are the unknowns. Again, I use personal experiences. I took care of my mother for 16 years after my father's passing. I'm an only child, so I'm it. And now the child becomes the parent. My mother had a severe case of dementia and diabetes, amputations, all of that, living independently after my father's passing and then living with us. I have a family, running a practice. I have a wife as well, and gets difficult. And then you've got to start making these healthcare decisions for those now parents who took care of you all your life. And those are some really heavy duty decisions. In my mother's case, loss of a leg, dementia, placement into a nursing home after we couldn't manage her care at home. Financially, big burden, extremely large burden. So those are the things that we kind of look to. And again, not being a fortune teller, we just kind of look at really kind of taking a hold and see of what can happen to a family. Incapacity is really one, obviously, during our lifetime. If we have young children, who are going to take care of those children if something happens to us, car accident, plane crash, whatever. And now with COVID coming in, that's a big major issue. The other side of that, of course, is kind of death capacity or planning for death. And what do we do? Who's going to pay for a funeral? Who's going to, pay for long-term care? What kind of expenses are we going to be looking for? Who are going to take care of the children from what bank account? So those are really some major issues that we need to look at as estate planners, and certainly finance people as well. Financial planners will be looking at that too. I use the term holistic in that, and I think I can speak for Alyson, is we've taken a kind of a different approach. The worst thing that you want is to have happen is you don't see your client for several years. You may plan something today in 2020, 2025 rolls around, their whole life has changed. Maybe there's an illness, incapacity. So you're kind of taking a look at what's going on now, what potentially can happen, and you look at all the potential factors that may come into play, and you put those into your bag of tricks and see what you can come up with. So hopefully that's kind of the overall perspective of where we come from, or at least I come from, looking into an estate plan when new clients come in.
Okay. Now, what specific documents or specific components would be included in a full estate plan?
Yeah, so typically for us, when a client walks through the door, as Frank said, we're thinking about both incapacity and death. And so when we think about incapacity, we're thinking about if somebody is alive but unable to manage their finances, who's going to do that? The document that we use to appoint an agent is called a power of attorney. And in the state of Connecticut anyway, a power of attorney gives you authority to manage someone's finances and authority to manage their personal affairs. So what are personal affairs? Well, it could mean something like changing a post office box or applying for insurance for someone. So there's, selling their home. There's a wide range of things, but the power of attorney will enable the agent, meaning the person who's named in the document, to act on behalf of the principal. The principal is the person who is creating the power of attorney, investing the power in the agent. Typically in Connecticut, we use what's called a durable power of attorney. That means that it's effective when you sign it, but if you become incapacitated, it quote unquote survives your incapacity, meaning the document continues to be in effect in that situation. So the first document that we do is a power of attorney, so that if someone is incapacitated or perhaps just unavailable, looking on the bright side of things, which is important to do these days, maybe somebody's traveling in Europe and needs somebody to do some things for them here, right? So there can be other instances in which you use a power of attorney, but generally when people execute a power of attorney, they're usually thinking about what happens if they become incapacitated. So that's the first document. What the power of attorney does not give you authority to do in Connecticut is to make medical decisions. So in Connecticut, to make medical decisions, you need to name a healthcare agent. That is typically done in Connecticut. We have a sort of combined form that does a couple of things. It names somebody to make your healthcare decisions for you. That's called, your agent. And it also sets forth your wishes. So it talks about if you were permanently unconscious or terminally ill, whether or not you'd want to be kept alive on life support. And that's a big issue these days. A lot of people are calling me and saying, I executed my living will and I didn't really think about it when I did it, but what does it mean when it says that if I'm terminally ill, I don't want life support? Does that mean that if I have COVID, I won't get a ventilator, right? So people are really taking a close look at these documents these days, but it is important to really to think about what you would want in different situations and to convey that to your family and to put it in writing and to convey it to your family, because it sort of takes the onus off of them at a really difficult time. If they know what you want, they don't have to agonize about it as much. So the second document then that we do is the living will, which, as I said, sets forth the agent and talks about what your wishes would be if you if you were in certain medical situations. So that's the second document. The third component of the estate plan is thinking about death. And that's thinking about, who are my assets going to pass to, and how am I going to protect my family, take care of my family if I pass away. And that can be done through a couple of different documents. And I think we're going to talk in depth about them, but it can be done through a will or a trust. But the idea is that you are somewhere leaving instructions as to, first of all, who's going to inherit your assets. Second of all, who's going to be in charge of that process of marshaling your assets, getting them together, getting them liquidated, distributing them. And then thirdly, you can use your estate plan, and we'll talk about this in more depth, but you can use your estate plan to provide various types of protection really for your loved ones. So you can provide, for instance, for an elderly parent you're caring for, if you were to die before that parent, you can leave, assets to care for them. You can leave instructions for that. Same, of course, with minor age children. You're going to want to really think through who's going to manage the money for them, who's going to take care of them. And sometimes even just for people who have adult children who are well, they still say to me, and I get this request all the time, Frank, I'm sure gets the same. How can I make sure that if my kids inherit what I've worked for my whole life, how can I make sure that if they get divorced, their spouse isn't going to get it, right? That's a biggie. Everybody wants to know that. I don't have a single client who doesn't ask me that, just about. So that's a big one. Sometimes people are worried about the health of their loved ones. How can I make sure that if, I might have a loved one who's disabled, how do I make sure that if I leave them money, that they can still get the health insurance and other government benefits that they need? So there's all types of things that enter into the estate plan, but the primary documents are going to be the power of attorney, the living will, and then some document that talks about how your assets are being distributed and who's managing them, whether it's a will or a trust. And we'll get into talking about those different things.
Yeah, I think Alyson brings up a good point. The conversations with your family members, your healthcare agent, is not a comfortable, discussion. It's not a dinner conversation probably, but it's a conversation that your children or your healthcare agent needs to, go through with you. These are your wishes, not theirs. You may not agree, but this is their, wishes, and I think it needs to be expressed to them clearly in a situation where they may be brought into it. So.
Yeah, and I think that's a good point, Frank. It's really, some of these discussions are hard and people avoid having them. But what happens if you avoid having them is that when you're in crisis, your family's stuck because they don't know what you want. They don't know what the assets are. They don't know how to manage things. And it's really very difficult for families. So I really encourage people to, to have the hard conversations. And oftentimes I'll say to them, if you want to schedule an appointment with your kids just to talk about these issues, just so your kids understand the estate plan or your loved ones, whoever they might be, then let's do that. I think Frank and I have really gotten to the point where we think that it's more than just executing a document. We need to really get the family involved, make sure that they understand they're on the same page. They understand their loved ones' wishes. So, that's really been a goal of ours, is really to expand on just the general planning and to take it to the point where family members are involved, they understand the process, sort of in the hopes that in the end it makes it easier for them.
Okay, can we come back to this issue of trust and will, or trust or will? Because it's my understanding there's some real similarities, but some also big differences as well. You've got the on the trust side, the trustor, the trustee, and the beneficiary. On the will side, the person, and then the executor, and then the beneficiaries, plural. Could you just expand on that, please?
Yeah. So I think the most important thing to understand before you get into a discussion about a will or a trust, the most important thing to understand is to kind of start at the really beginning with how assets pass. And so first we have to talk really just for a minute about different kinds of ownership of assets and how they pass. And then that makes it easier to understand a will and a trust. So there are really three types of scenarios where assets will pass. One is that you may have some type of asset that you own with a co-owner. So let's say I own a home with my husband, he and I are co-owners. Even if I do some type of document that says, hey, I'm not leaving anything to my husband, I'm mad at him, I'm cutting him out, he's going to inherit my house because he is a joint owner, okay? So that's the first thing. The second thing is that you can have an account that has a beneficiary on it. So if you have, for instance, a retirement account, which most people have, and you name a beneficiary on that retirement account, that asset is going to pass to the beneficiary, regardless of what your documents say. So those are sort of like the simplest wills are actually just co-ownership and beneficiary designation. The assets that you own in your name only with no beneficiary and no co-owner are the assets that would pass under a will. And Frank, maybe I'm going to let you explain what a will is exactly, but I think it's important to understand before you even get into talking about that, just that when you talk about a will, you're talking about passing those assets that you die with in your name only. You're not talking about joint ownership, and you're not talking about beneficiary. It's assets in your name only with no co-owner, no beneficiary. So Frank, you want to...
Yeah, absolutely.
Yeah.
And I think it's kind of interesting, and I think for your class as well, Professor, is that beneficiary designations, it's amazing when, time goes by, things happen in our life and we neglect to update our beneficiaries. So for example, I have a case that I handled for a client 14, 15 years ago out in the Rocky Hill, Connecticut area. They were married at the time. A couple of years ago, I got received a call from the husband telling me that, hey, what should I do with this death claim form on, Phyllis? And I go, well, I didn't realize Phyllis passed. That was his wife. Well, he said, we divorced several years ago, but I haven't seen you, Frank, so I'm just letting you know. And I've got this death claim form that I have to fill out for Metropolitan Life or John Hancock, wherever. And I said to the client, I said, do yourself a favor, fill out the form. Sounds like you may be a beneficiary on your ex-wife's life policy, and send in the death certificate and the completed form. A couple of weeks later, I get this email picture of my client sitting on a motorcycle with the kickstand and his hands back, feet up on the handlebars. And I said to the client, I said, it's a wonderful picture of your motorcycle. Can you explain a little bit? I don't, there's no context here. And he said, well, Frank, if you remember, my ex-wife, Phyllis, hated motorcycles. And I received a $250,000 death benefit because my ex-wife never changed it on the life policy. So therefore, I got this motorcycle. In Connecticut, we have a no helmet rule. So of course, he's leaning the back of a Honda Goldwing for $35,000 out of his $250,000, and he's loving it. So it's important, by the way, just to make sure, whether it's annually, biannually, just to check and make sure beneficiaries are changed, if circumstances change, estranged children, whatever the case may be. Those are important. So I'll jump a little bit to the will. So I like that story because it's a real story, and my client loves it because he's $250,000 richer now because of an ex-wife not changing the beneficiary. So
I think it's also important because it demonstrates, I think a lot of people think that when they sign a will, that's where their assets are going. They forget about the beneficiary designation. And so many times people get married or divorced, but don't change their beneficiary designations. I mean, we get a number of these cases every year. So the assets are not passing where they think they're passing. And there's not a lot that can be done about it legally once it's happened. So it really is important for people to understand that. But anyway, go on, Frank.
Yeah, sure. So a will is really nothing more, in really simplistic terms, is nothing more than kind of an instruction to the probate court to how you want your assets distributed. Are they going to go to your spouse? Are they going to go to children, grandchildren, whatever? And really picking and choosing who, well, an executor, right, male, or executrix, female, who's going to be handling your estate through probate. As Alyson mentioned earlier, solely owned items, solely owned assets are the only thing that truly passes through probate court. And again, it's how it gets distributed to your beneficiaries and who are they and how much they're going to get or receive. Generally, probate court, at least in Connecticut, takes upwards to about a year. There are ways to avoid probate. Alyson will get into that in a minute, or shorten probate. But by and large, it's generally about a year in Connecticut. I've seen the same in Massachusetts. I have current cases that are going on for about 3 years because we have children, adult beneficiaries who are arguing basically over the split of the pot. You know, there's not the big rainbow or golden bucket at the end that everybody thinks there is. So it's funny. I was an only child, so I never had any of these issues. I have 2 children, and I can see it from early on. This, who's got the bigger slice of cake, or who has more on their plate than or meal on this one. So, and that kind of extends and goes on through adulthood. I can tell, and I'm sure Alyson has the same thing. We've been involved with cases where you're arguing over, Christmas ornaments, grandma's plate that they haven't seen in the attic for 100 years. But it gets it gets down into that dirty and that crazy stuff that really can make these estates go all over the place. But by and large, mostly, at least in Connecticut, it's 1 year. And again, nothing more than a will is nothing more than an instruction guide, if you will, to the probate court judge, how you want your assets distributed.
Okay. Now, you mentioned avoiding probate. I was very interested in hearing more about that, because you do hear these bad, stories about, probate fights and things like that. How do you avoid that?
Yeah. So essentially, and this is why it's so important to understand what it is that's subject to probate in the first place, right? And as we keep saying, what's subject to probate are these assets that you die with in your name only, with no beneficiary or no co-owner. And when we talk about probate, that's the process of the probate court, admitting the will, reviewing it, and then there's about a 6 months to a year process where you're, allowing time for creditors to present claims, and you're filing tax returns and things like that. So it turns out to be this lengthy process. And over the years, people have gotten sort of more and more of a desire has developed in the public to avoid this process. And the way that you avoid it is by, simply put, by not having any assets that are solely owned when you die. How do you do that? Well, you can do it through beneficiary designation or through co-ownership, but the best way to do it is through a trust. And so a lot of people ask me, what is a trust? It's sort of like this thing that you hear about, but what is it actually? And what I tell people is, think of a trust as a basket. A trust is essentially something that holds your assets. And the trust document then that you execute with your attorney is really just a set of instructions for how and when assets go into that basket and come out of it. The way typically that people avoid probate is by creating what's called a revocable trust. Okay? And a revocable trust is a trust that says, while I'm alive, my money's mine and I can do what I want to with it. Okay? That's the general concept behind it. I'm creating this trust while I'm alive. I'm going to take my assets and I'm going to put them into this trust. However, I retain full control over my assets. So while I'm alive, my money's mine and I can do what I want to with it. And then the trust says, when I die, here's what I want to happen with my money. And it might talk about, it's going to be held and distributed to my children or used for my spouse or whatever. But the idea with this trust is that if you think of it as a basket, you are creating this trust today, you are putting your assets in the trust. So you're literally putting them in the basket, and you are executing this trust agreement that talks about how and when assets can come in and go out of that basket. Now, once assets go in that basket, they are owned by the trust, not by you. So when you die, you don't have any solely owned assets. The assets are owned by the trust. So they're not passing under a will and they're not subject to probate court. Instead, what's happening is that they're being administered in accordance with the instructions in the trust. And let me explain a little bit about how that works. There are 3 basic roles with a trust. There is the grantor, sometimes called the settler. That's the person who creates the trust. There's the trustee. That's the person who has the legal authority to manage what's in the trust. There's the beneficiary. That's the person who's entitled in some way to what's in the trust, entitled at the end of the day to use and benefit from what's in the trust. What happens with a revocable trust is that you create it yourself. So you're the grantor or the settler. And generally in the beginning, you are the trustee, right? So it's my money. I'm putting it in the trust. I'm retaining the legal authority to do what I want to with it. So I'm still the trustee and I'm the beneficiary because while I'm alive, this money's being used for me. So, that's the general idea with a revocable trust, is that you are in essence creating this place to park your assets. And the biggest purpose behind it, and it fulfills a lot of functions, but the biggest purpose behind it is simply to have a place to put your assets so that when you die, they are not solely owned. The trust is better than, in many ways, a beneficiary designation or co-ownership because, for exactly the reasons that Frank and I talked about, beneficiaries, first of all, it can be very hard to, you might have a succession of beneficiaries. I want this person, but if they die, I want this person. I don't want them to get all the money at once, that kind of thing. You can't really do that through a beneficiary designation. And of course, the problem with co-ownership is that whoever you own it with might die first. And then if you are the survivor and you inherit it, you now have a solely owned asset. So what we do is we create these revocable trusts. We take the assets, we transfer them into the trust. And then the person who created the trust is the beneficiary and the grantor throughout their lifetime. If they become incapacitated or when they die, they've named a backup trustee. That person steps into their shoes and has the authority under the trust document to distribute as the trust instructs. Okay, it could be very simple, liquidate, distribute to my kids. It could be much more complex, liquidate, but we're going to hold in a continuing trust to protect my kids in some way. And, you know, we could talk about that aspect of it too. But the general idea with avoiding probate is simply that you're avoiding having solely owned assets. And usually the best, most comprehensive way to do that is through a revocable trust where you're retaining full authority and control. But technically speaking, legally, you are not the owner, so you are not going to have solely owned assets when you die. Does that make sense?
Mm-hmm.
Yeah. Okay.
Yeah, absolutely. Well, it sounds, you know, when you're thinking about trust versus will, it sounds like your stance is you should always have a revocable trust, but there's got to be times when perhaps it's like, I don't need that, or maybe I don't need that yet.
Yeah. So here's what I tell my clients. So people have varying degrees of concern about probate court, and part of it is your perspective. Some people say to me, well, I don't really care if my heirs have to go through probate court because I'm not going to be here. It's not my hassle. But that's a fair point, and let me tell you why. Because the reason that it's a fair point is that when you create a revocable trust, it is a much longer process, and it's twofold, right? You got to create the trust first, then you've got to transfer all your assets in it. So it's quite an amount of work. It's more expensive and it's more work. And what I always tell people is, you know, when you are creating this trust and transferring your assets into it, you're really doing the work that it would take a year to do in probate court if you died without the revocable trust. You're sort of doing it now while you're alive. You're marshaling your assets, putting them all in one place. So, you know, and so the question becomes, is that important to you? And frankly, whether or not it's important to people sometimes depends on how likely they think they are to die in the near future. So as a general rule, the more likely that people think they are to die in the somewhat near future, the more likely they are to want to say, I want it to be easy for my family. A lot of young couples who come in to see me, they're making plans just in case, but they're not expecting to die. And they're saying to me, I don't know that I want all the time and expense of a trust. A will is okay. I'm going to provide for my family. And if something happens, yeah, it's going to take longer for my executor, but at least I don't have to pay for the trust now, and I don't have to do the work of marshaling my assets now. Fair enough. There also are some cases in which you have to have a will. There are some sort of oddities in the law. There are certain types of trusts that you can create if you have for instance, a spouse who is disabled or who you think might need long-term care when you die. Those types of trusts very often need to be created under a will, because the exemptions that allow you to create these kinds of trusts, and in essence, these trusts would allow your spouse to keep money on the side while also qualifying for government types of health insurance. Sometimes the law says that if you have what's called a testamentary trust, which is created under your will, that type of trust is exempt and others aren't. So there are actually times that you need to have a will, and the will might be quite involved and might have a lot of planning in it, but for certain reasons, certain oddities in the law, it has to be done through a will and not a trust. So it's kind of interesting, the choice between the two. It's more complex than it seems.
I have always had a thought, and maybe this is wrong, that a lot of times people are too late getting these things going. Now, obviously, you don't need much in terms of estate planning if you don't have any assets. But I've always thought that people start accumulating assets and they're not thinking about, well, that's not going to happen to me for a long, long time. So when should people start, doing this kind of planning?
You want to take that one, Frank? What's your thought on that?
Wow, that's a good question. Well, now with COVID, I think everybody should start early. It really does range. I mean, I'm getting younger clients coming in now, especially, and it goes in phases. You've got kids out there at college, obviously that might need some type of, estate planning done. They're out off campus or on campus, thousands of miles away, maybe even local. So there's situations where, once you're an adult, we as parents can't make decisions for our children. And there might be healthcare decisions or whatever that we have to make, financial decisions. Alyson mentioned about powers of attorney. So those are important things, documents and things that you start to need early on, college age. I've got young couples that are coming in now, 20, 21 years old, having families starting younger. Certainly that's really a critical stage. Who's going to take care of the children if something happens to them? God forbid, a car accident and they're both, there's fatalities. We never want to see those things happen. Yeah. We never want to see our children pass before we do, but that rule's been broken many, many times, at least in my experience. So, planning early is certainly, again, I'll let everybody use the crystal ball here. We never really know, but planning as early as we can. Again, as we start to, Professor, as you alluded to, we start accumulating assets. Things start changing in our lives, our family. We have to start looking at perhaps becoming the parent of our parents, who is going to take care of them, where they're going, how that's going to play out for ourselves, whether there's disability or incapacity for ourselves. So it can start, I've seen it start very young, young families, kids in college now. The COVID situation that Alyson mentioned earlier, this is bringing on a lot of people are coming out now and really starting to rethink and reevaluate their financial, obviously their portfolios has changed with the marketplace changing. We see a lot of the real estate now, they're moving out of cities. They're buying homes and out in the Berkshires and up north just to get away from the city, because now we're all Zoom and not, we're all working remote. So I think the earlier, the better, certainly. And again, I think it's, you look at each family's goals and it's a case-by-case basis. How to plan ahead, what to expect. As Alyson mentioned, whether you go for a trust, whether you go for a will, what are your real goals here? What are you trying to avoid? What are you looking forward to expenses? So it really runs the gamut here. What when to come in and what to plan for ahead.
And Frank, I think your point is good, because a lot of people don't think about this. Let's say that you have a child who goes off to college. That child has turned 18. You don't necessarily have any authority to make medical decisions for them or to handle their finances if they get sick for a month. And that's something that people don't think of very often, but it's very much the case. It's important, even if you don't have assets, to vest somebody with authority to manage your personal affairs, to make medical decisions for you. And people have to remember, when your child reaches the age of majority, yes, they're still your child, but legally speaking, you're going to need you're going to need to be appointed by them to be able to manage their affairs. People don't think of that. Yeah. But we've gotten some number of calls on that recently, parents saying, wait a minute, you know, my kid's going off to college somewhere, and what happens if they get sick? How do I access their bank account? How do I, gotta have documents.
Yeah. I have a situation right now, not to take up too much time, but I have a case right now where a student, college age student, 20 years old, college, mom needs to handle a couple of personal things, not COVID related, but other related issues, medical issues out there. She can't speak to the professors. She can't speak to the college. She can't obtain medical records from the school. She has no authority. So with a healthcare agent or a power of attorney, at least that gives the parent, you know, the authority, wants to help, but she can't because her hands are tied to it. Again, age of majority, they're an adult. You can't get access to that. And in those situations, that's you know, quite difficult for the parents to handle.
For someone that has made a decision to, okay, I really need to have an estate plan, how long might it take, you know, beginning to end for that whole process to go through?
Part of it depends on what they're doing, right? So as we said earlier, a will is much quicker, and the reason is that all you're doing is executing a document that talks about how in the future your assets will be distributed. It doesn't involve necessarily changing title to assets or changing beneficiaries or anything like that. So it can be a 1 or 2 stop deal with your attorney. You know, you're going to come in, tell what you want, you're going to look at a draft, you're going to sign it, you're done. That's why a lot of people prefer a will. It's easier, it's simpler, makes a lot of sense for a lot of people. If you're going to do a trust, this is where the financial advisors and the people who help us come in, because once we create the trust, we have to put the assets in the trust, right? We got to fund it. So we either have to change the ownership on the assets or we have to change the beneficiary designation. That to some degree is out of our control. So we oversee that process and we help with it. But to the extent that we have a financial advisor who we work closely with, who's helping us change ownership and beneficiary, it can go pretty quickly. When we're writing away, you know, to some insurance company out in the Midwest, please change ownership on this life insurance policy, or please change the beneficiary. You know, sometimes you got to send 3 letters before you get a response. And if you call, they tell you to go online. And when you go online, you get a bot that responds to you and you know, is sending you a form. So it depends, but the funding aspect of it can take a couple months. What we didn't talk about yet, but what's also an issue is that sometimes we're doing types of planning where we're moving assets out of someone's name. And we might be doing that because it might be a client who is older or is concerned that they're going to need long-term care in the future, in which case they're coming to us and saying, if I wind up needing really long-term care, I don't want to lose all my assets. Can I take them out of my name? Can I protect them? I mean, it's complicated, but the answer is yes, you can. But doing some of that, there are some timeframes that are involved. And so sometimes we have plans that take place over a 5-year period that involve shifting assets. I mean, that's obviously on the way outside, you know, but it can be done in a week or 2 with a will. Funding a trust is going to take longer. And if it's a very complicated plan that involves moving assets, then it just totally depends on what your goals are in terms of how long it will take.
I personally love it when a client comes in and has a finance advisor. It's just makes my life that much easier. And by the way, your 3 or 4 letters, I've got about 8 going to one company, 8 times. Oh. It's just a nightmare.
I'm pretty sure the rule is that it hits the circular file the first 3 times, yeah. You know, and then finally someone pays attention to it. But you know, so it depends. It just depends how long it takes to get these trusts funded. But you know, but the part of drafting the documents is, you know, trust takes a little longer because it's a lot more involved. You're probably going to have 3 or 4 visits for that. For a will, you're going to have 1 or 2.
And I've seen, I'm sure, Alyson, you've seen the same thing. We've had a couple, I'm not, you know, picking on other law firms, and I've seen clients come in with these wonderful, you know, binders. and here's my trust, and I say it looks beautiful, and then I'm looking through the documents. Where are your funding? What did you put in? Funding documents. Where's that? Is the house in trust? Oh, I don't know. Here's the binder. And then I just kind of hand it back because I can't see any of what's been funded, what Alyson mentioned, funding, because that's what's going into the trust. And I said, it's really worth like birdcage liner. It's nothing. It's just this document. It's an empty document. Without the funding, that's the bigger part of it, if you will.
Yeah.
So and we find that.
I think that's a really important point, Frank, because sometimes people miss the forest for the trees, right? People go out and they pay for these expensive estate plans, and they've got a trust, but they don't fund it. And so what happens is they've still got solely owned assets, right? Those assets are still sitting out there. And then when they die, the kids come into our office and they're saying, well, mom or dad had a trust, so we don't need to do probate. Yeah, you do, because the assets did not get transferred into the trust. So if you don't do the two parts of the process, then the trust is worthless. But we see that all the time, that people don't really understand how the trusts work. So they go out, they get a trust, and they don't recognize that because it's not funded, it's not going to work. It's not going to avoid the probate process because they're going to die with solely owned assets. And then they typically have a will that says, well, when I die, anything that I die with should be placed in my trust. Well, that's great, but you got to probate it first. So, that was a kind of expensive thing that didn't wind up the way you thought it would. So that's why it's important to understand. You can talk about the trust just in sort of abstract terms, but if you don't get the concepts behind how it works, then you just wind up with something that doesn't achieve your goals. So I think that's something that Frank and I have really tried to educate our clients about. Here's why: if you want to do a trust, you have to be committed to the process and understand that you're going to have to work with us, help us fund this trust. And we're always very, very grateful when we have professionals working with us who understand that and can help us with that process. Yeah.
Once someone has done a good job of setting this up, setting up a solid estate plan, funding it properly, and all that, when, if ever, should that be revisited?
So that's a good question. There's two aspects to this. Number one, if you set up a trust and you are avoiding probate with it, then you need to continue to fund it, right? So if you go out and you sell your home and you buy a new home, and now your home is no longer in the trust, you have to understand the funding and stay on top of it, which is why Frank and I work so hard to explain that to clients. So part of it is that you might want to see your attorney every once in a while just to make sure that the trust is still properly funded. There's also, there are changes in the law, and sometimes, I'm sure you know how this is, sometimes the law doesn't change for a long time and we sort of get complacent and we say, oh, well, but this past year we had major changes. In Connecticut, we had a brand new trust code that really changes how trusts work in Connecticut. And we have the Secure Act, which totally changes how retirement accounts are inherited. So all of a sudden, we have a lot of impacted estate plans. So it's hard to say every 2 years, because it could be 2 years without much changes in the law. Then again, you could have a lot of changes in the law. So I tell my clients, hey, listen, look, if you're watching the news and you hear that there's been a major change to the estate tax code or to, inheritance of IRAs or something, pick up the phone and give us a call. Otherwise, check in every couple of years, just so, number one, we can see if there are changes in the law. Number two, see if there are changes in your assets. And number three, see if there are changes in your family, right? New people are born, people get married, people get divorced. Let's make sure we don't have the person who's now been divorced out of the family, who's now the outlaw, not the in-law. Let's make sure they're not in your documents, And I have to admit that I stole that phrase from Frank. That's Frank's phrase.
That's a good one. That's a good one. Well, now you just brought up in what you just said a really interesting thing, because where I'm sitting right now in Dudley, Massachusetts, I go 2 miles to the south and I'm in a different state. I go 6 miles to the east and I'm in a different state. What do you have to do, to considering the state-by-state issues?
Yeah. So the general rule is that if a document is validly executed in one state, it's legal and effective in the other. Okay, so for instance, if someone comes into Connecticut and executes a will, in Connecticut and then dies in Minnesota, that Connecticut will is valid in Minnesota. But the question is, are you subject to different estate tax in Minnesota than you were in Connecticut? There can be a lot of issues. Frank, I'm going to maybe let you take that and talk about just, yes, the document is effective, but what happens if it's a really different state with really different laws?
At least in my practice, I've seen, to Alyson's point, theoretically, the other state that you go to, whether it's, Rhode Island, Mass, or wherever, theoretically, they're supposed to accept the documents that you prepare in the state. As long as it's legal in the state that you're in, Connecticut, Mass, wherever, then it should be legal in wherever you go to, east, west, north, or south. The only problem that I see that crops up sometimes are what we call the advanced directives, where the healthcare proxies may be different, living wills and powers of attorney. So yes, on the last will and testaments and trust, you got to accept that to accommodate whatever state you're going to, and that state has to accept it. I struggle sometimes because I do have clients that go out of state and then are struggling, saying, well, this is you have a Massachusetts power of attorney, but you're in Connecticut, or you're in Rhode Island, or you're in North Carolina. So that becomes problematic. And especially if you're, you don't have the capacity to create a new one, what do you do? So you really then go back and say, look, it's a durable power of attorney. It's legal in this state where it was created. You got to accept it. I've had situations where it's a nursing home situation and they're arguing because it's an out-of-state document. But my client, who may have retired in Florida, doesn't have the capacity to sign. They don't know who they are, dementia. So, almost as an accommodation, they'll do it, but it's a struggle sometimes. So I find it more on the advanced directives as opposed to a will or a trust. The will or a trust, I've never had a problem in another state accommodating it. The powers of attorney, advanced directives, that's where it gets a little bit more gray. And it depends really on the state and the agent or agency, hospital, doctor, wherever that you're using it with. Banks, I won't mention certain banks, but some banks are they become problematic in dealing with these things, especially out of state. Durable, as Alyson mentioned, like a power of attorney, means exactly that. It's durable. That means forever. I've had banks argue where you've got to have one every year. Well, that doesn't make sense. What happens if you become incapacitated during that year? What do you want me to sign? What name? Barack Obama, George Bush. It goes. It really goes.
And I think that part of it is that it's the difference between, yes, the document is legal, it's valid, but if the people who are on the receiving end of it, if they're a bank, it's a teller in a bank, and they're not, they don't necessarily know the law. So, or if someone is admitted in a hospital in another state, the hospital may realize that, yes, there's a living will from the state of Connecticut and it's valid here because it was properly executed in Connecticut, but the doctors who are trying to work under that document haven't seen it before. They're used to the document from their state. So they're looking at it saying, well, what does it mean to be terminally ill in Connecticut? Is that the same thing that it means here? So I think it's not that they're not valid. It's that, as Frank said, it becomes problematic. The other thing that I think is important to think about is if you move to another state, there are certain laws in that state that you are subject to. So for instance, state estate tax. Different states have different exemptions from estate tax. And so somebody could be living in Connecticut where there's a 5.1 million exemption from estate tax and have a document that doesn't address estate tax. They move to another state that has a 1 million exemption. They might be subject to estate tax. Yes, the document works. It's still a valid will, but it might not be addressing some of the state law issues that you may have because you've moved. Does that make sense the way I explained it?
Yeah, absolutely. Wow. We've covered so much, and thank you so much for that. What else that we haven't covered do you think the students need to know, or do you have any final words of wisdom?
So the one other thing that we could talk about very briefly, just so that they're aware of the differences, we talked about a revocable trust and how you avoid probate with that. we didn't talk about irrevocable trusts, and that's in part because that is such a huge subject that we could spend another couple days talking about it. But I do want to point out that there are two very different types of trusts out there. Revocable trust kind of has this concept: I'm taking my money, I'm putting it into this trust, but while I'm alive, I'm still in control of this. It's still my money. I still have the right to use it. Irrevocable trusts are the opposite. That's when you're saying, I'm taking my money, I'm putting it into this trust. It's no longer my money anymore. It belongs to the beneficiaries. And there's all sorts of different types of irrevocable trusts that you can do. But the bottom line is that there's a very different, that those two trusts are very, very different. One is predicated on the idea that while you're alive, the asset is still yours, and that's the revocable trust. The irrevocable trust is predicated on the idea that the asset that you're putting in there, that you are in some way giving up some control of it, that it is in fact not your asset anymore. And if you can remember the difference between those two types of trusts, then a lot more will make sense to you, because the question probably that your students will encounter in the future is, hey, I did a trust. Does that mean that my assets are protected from a creditor? I'm getting sued. Does it mean that my assets are protected if I need a nursing home? The way to think of it is this: it's very simple. If you have a trust that says, well, I'm alive, my money's mine, and I can do what I want to with it, then the general answer is that it's your money and you need to pay your debts with it, right? If you have a trust that says, I'm giving away my money, I can no longer, I can no longer access it or use it, and of course there's many variations of that. But if you have that type of trust, then yes, your assets may be protected. But there is so much confusion in the community. People just think if you have a trust, your assets are protected. Trusts do this or that. The reality is that it very much depends on what kind of trust you have. And so the first thing that you have to be thinking of is, what kind of trust is my client talking about? Is it the type where it's still their money and they're maybe avoiding probate or doing something else with the trust? Or is it the type where it's not their money? And that's the first thing you have to do before you do anything else with the trust. You got to figure out, what kind of trust am I dealing with? Because if you lose sight of that, you're going to think that the trust does a lot of things that it doesn't do. That's where I think some of the biggest misunderstandings come in. So I hope that made some sense. It's difficult to, it's such a vast topic that it's difficult, but I really, really think that the one thing that anybody who's going to work in finance or in accounting or in law has to understand is the basic difference between these two types of trusts.
Yeah, I have.
Thank you. Yeah,
I just have one brief statement. I think, in just to summarize, I think for when you're going out, whether it's finance, whether you're going to be advisors, accountants, whatever, I think one of the things is really look at your clients. What are their goals, not your goals, and try to explain to them as best you can, because it does it's overwhelming. Let's face it. But I think you really need to know your clients very well. You've got to figure out where they're coming from. If it's finance, what's their risk tolerance? Because they're always going to come back. They're always going to be finger pointing, right? So the best that you can do is really get a lay of the land when you're meeting a client. Full disclosure, transparency. Get to understand them. What is it that they're really trying to accomplish here? Look at their goals, where they've been, what they want to do. I can't speak enough to that, because we come back and we really want to try to address their concerns, their goals. And I think if you look at that and try to accommodate their needs, and again, things change. It changes daily, it changes, weekly, but at least at that time, the snapshot that you have, at least you're trying to work with them, and obviously, explain as best you can and lay everything out for them and what they're, to meet their expectations and their goals.
Yeah. And at the end of the day, an estate plan is really, people come to see us because they want to take care of their families. That's really what an estate plan is about. It's about wanting to take care of your family. And so if we just come at it from a legal perspective, we might miss what's the most important thing to them, why they're sitting in front of us. Everybody has concerns about how their family will do when they pass away or if they become incapacitated. And we really can't do our job if we don't understand what those concerns are. That's, I think, the biggest thing. You can never do estate planning in a vacuum. You have to understand what it is that worries people about their families, and what it is that, how they envision taking care of their family. Then we can put it into a legal document. But really, the biggest thing for people to understand is that estate planning is about taking care of your family.
Well, that is a fantastic way to tie it up. Thank you so much. Thank both of you so much for taking the time to share your expertise with
Thank you
our
for having
planning
us.
students.
Thank you very much for having us. Thank you.